I'll try that again. Good morning, everyone. We're waiting just a second to get everyone signed into the webinar. We should start momentarily. While we're waiting for that, let me just thank everybody for showing up today. This webinar is always one of the top webinars we have during the year. We appreciate all your time. We know it's a busy time of year, and we know that this is good information that you'll need. So we appreciate the time. I'm going to get started. Okay, thanks for joining us today, December 4th, for our webinar, New Laws for the New Year 2026 edition, presented by Ethos Human Capital Solutions. My name is Denise Keddy, and I will be your moderator for today, which means Linda has to change the slide. It's one of those mornings, everyone, just so you know. There we go. Again, my name is Denise Keddy. I'll be the moderator for this session. A couple quick reminders before we get into today's important topic. The webinar is going to run about 60 minutes in total. Please take a moment now to download the slides. We're going to show you the link in a second, and I will put it in the Q&A area if you need it, so don't worry about that. If you have questions during the presentation, please post them in the Q&A area on the dashboard at any time during the presentation. If you would like your question directed to a specific panelist, you can note it when you're sending in your question. If you want to share this webinar when it's done with your coworkers, the webinar will be posted in the next 24 hours on the Ethos HCS YouTube channel and also on the Merhab Robinson and Clarkson YouTube channel. Just a reminder, today's webinar is being recorded and all accompanying materials are protected by copyright. Our presentation today is intended for information purposes only, and you should not rely on it to reach a conclusion in any area of law. We recommend that you consult with your legal counsel to address your specific situation to ensure that you have the most current information on legal matters. We're having a little technical difficulties in the background, as you can tell, so hopefully we're going to get that resolved. Ready to switch the slide?
Yes.
Okay, there we go. Okay, to access the handouts today, you can click on that link. If you don't get that, you can send me a question in the Q&A and I'll make sure that I get back to you with that. Again, ask questions by typing them into the questions section. So let me introduce you to our presenters. Linda Duffy, the president of Ethos Human Capital Solutions. Linda has over 30 years experience and has built her business and team to deliver outstanding consulting, recruiting, training, payroll support, and organizational development programs. Linda and her team are known for building the magic of human connection with your company by developing strategies for business leaders to get the right systems, people, and culture in place within your organization so that you, as a business owner, can focus on achieving your goals. Today, we are lucky to have two legal experts with us. Our first legal expert and returning webinar person is Marla Merhab Robinson, partner and head of the transactional department at Merhab Robinson and Clarkson Law Corporation. Marla practices primarily in the areas of corporate mergers and acquisitions, real estate finance, and employment law, and has been helping business owners for over 34 years. Her reputation among her clients and peers is that she delivers personalized service and is responsive, reliable, and very well respected. Marla is a sought-after speaker in the community regarding corporate governance and employer rights. Our second legal expert today is Sean Larson, founding partner of Larson and Nador LLP, a boutique law firm. Sean counsels employers in all areas of employment law and represented businesses in federal and state courts. Sean has an expertise in handling and advising employers on social media network issues, examples of Facebook. He regularly lectures before employer groups and conducts in-house training workshops regarding compliance with California federal and employment laws. Sean is also fluent in Spanish, something that I know many of our people are interested in knowing. Linda, do you want to talk about the HRCI certification?
I do. Thanks so much, Denise. Thanks everybody for joining us today. So yeah, as Denise said, we're having some technical difficulties, but it'll all work out just fine. So for those of you that are HR professionals and have a certification through HRCI, once you complete this link, you'll get to the end of the survey and there'll be like a thank you page. On that page, you will see a link there that will direct you to your certificate of completion or attendance. So just know we'd love everybody to complete this survey. It will go out to you tomorrow. And we do love the feedback, and we actually do read all the comments. So I would ask everybody to please do that, but it's a requirement if you need the certification for HRCI credits. Thanks. Okay, so today's agenda, I'm really excited to have two attorneys with us, and I'm honestly doing all the easy stuff up front and just getting out of the way so they can do all the heavy lifting, and then we, of course, will save room to answer questions at the end. So there are some statewide changes impacting California employers. The good news is there aren't a lot of updates you need to do your handbook this year, but there are some significant changes to California law, so you're going to want to know about those. So this is the agenda that we have for today, but we're going to break this down into smaller bite-sized chunks, starting with minimum wage. So everybody knows minimum wage is indexed. It goes up periodically. January 1st, it will be $16.90. That's the statewide minimum wage. That means the exempt salary increases because it's twice that, right? So $16.90 times 2080 hours in a year times 2, and you get $70,304 per year. So that is the minimum salary you must pay somebody to be salaried exempt in California. Now, the exceptions to that are if they're a computer professional, there's a completely different rule, right? If they're a doctor, there's a completely different rule. So you want to make sure that you don't fall under one of those job categories with your people. And you also want to pay particular attention to local minimum wages. So if you live in certain cities in California, you'll know that it could be starting at $18.63, or $24 an hour. It just depends on industry. It depends on where you're located. But for the statewide, that's what we're looking at. So as I just mentioned, there are some specialty wages. So fast food, for an example, is at $20 an hour right now and scheduled to have an increase in July. There's healthcare minimum wage, some hotel workers. And so if you want a list of like the local ordinances, like the cities, you can click on that link there and they keep it updated. That comes through the Labor Commissioner's office, but you can see through someplace at Berkeley. So that's all I wanted to mention about the minimum wages, other than this always results in some wage compression for those of you that employ a lot of minimum wage workers. So just remember, if you've had somebody at that rate for a year, then you're going to bring somebody with no experience at that same rate. You're going to want to take a look at that and see what you can do to adjust everybody else. Next thing is the IRS always indexes the amount that you can contribute to your 401k or 403b or whatever plan type you have. And so there's the standard that you can do. But then for those of us that are over 50, you can have this extra catch-up amount. So for next year, it's going to be $8,000. And then there's also something now called a super catch-up, which is another $11,250. Here's the thing. This was part of the better, beautiful, big, beautiful, better, whatever law that Trump passed earlier. And in that bill, it also said that if you earn more than $150,000, then you must make those catch-up and super catch-ups as Roth contributions. It's not through your regular 401k. So if you have a 401k plan, make sure you are adding a Roth component to it if you haven't already. Talk to your 401k advisor. If you need help or don't have one, reach out to us. We can connect you with somebody. But you want to make sure that if you are over 50, look at how much you're going to be reporting in wages to see if you can add either the $8,000 or the $11,250. There were a couple of bills that were passed regarding pay transparency and pay equity. You might remember a few years ago, there was the requirement that if a candidate asks, what does this job pay, that you were going to have to include, or share that information, include it in job postings, that type of thing. So now they've sort of refined some of this to say the pay scale now means a true good faith wage range or hourly range that you're going to pay somebody for that job. But you also are going to need to provide that if an employee asks, in addition to a candidate. So there's some things here on both of these bills that you're going to want to take a look at. For those of you that have 100 or more employees, you already have the paid data reporting. But right now you have 10 different job categories, and in 2027 it's increasing to 23, and then it's going to go up from there. And just a reminder, any demographic information that you do maintain so you can do their report needs to be kept separately from personnel files. All right. This is actually good news for employers. Yay. So hopefully everybody knows that for those employees that are working more than 5 hours in a day, but less than 6, they have the ability to waive their meal period, right? We're not talking about a general meal period waiver. Like Sean and Marla would tell you, you can't just have employees go, I'll just sign a document saying I don't want a lunch. Doesn't work that way in California, but there is that narrow exception that if they're going to be working more than 5 but less than 6, then they can agree to waive it with the employer. So now the good news about this, and this came out of a court case, Bradsbury versus the Car Operating Inc., said that you can prospectively waive that, meaning you don't have to have them fill it out every single day on the off chance that they want to not take their lunch. You can have them fill out one, and it can just sit in their file, and so it can be used for any future meal periods where they're not going to want to take a meal, if that's okay with the employer, of course. It just has to, you have to make sure that they know that they can revoke it at any time. So that's actually less paperwork for everybody. So I think that's a win for employers. Tips. So gratuities, meaning gratuities. So there's already a section in the labor code that prohibits employers from taking or deducting tips. And so that's the labor code section if anybody wants to read the details of it. The Senate bill just basically added some stronger enforcement teeth. So the labor commissioner can now investigate or issue a citation or file a civil action against the employer. So you want to make sure for those of you that do have gratuities in your business to make sure that you are following the law on that very carefully. There's some new required notices. Now we don't have the notice yet, but by February 1st of next year, the Labor Commissioner's Office will publish the template, is what I'm trying to get out. So what you have to do is include this notice. It's going to cover workers' comp rights, immigration enforcement protections, concerted activity rights, law enforcement interaction rights. There's a whole bunch of things that has to be included. You're going to have to give it upon to all employees by March 3rd, but then you have to do it annually, and you also have to do it for all new hires. So in addition to the other notices you're already giving your new hires, add one more to the pile because that has to be included as well. And then my last slide before I hand it over to Marla is this is just a new record keeping requirement. So again, don't think you have to do anything about your handbook for this one, but internally you need to know how you keep your files as they relate to an employee's personnel record. Just got a little bit more complicated because now you have to keep very specific information regarding training programs. So your file, which also means if an employee requests a copy of their file, this is something you're going to have to turn over to them. It has to have the employee's name, the person that did the training, the dates of the training, the core competencies covered, and then if there was any resulting certification from that. So just remember also under that section of the Labor Code, employees have a right to receive copies of their personnel file, or at least most things in the personnel file. And also remember that anything you put in a personnel file can be discoverable later if there's ever some sort of court case filed. So you want to make sure that you can, that you have everything, you know, tip-top shape, following the law carefully, and everything that you're supposed to include is included. And with that, I'm going to turn it over to Marla Robinson.
Can you hear me?
Now we can hear you.
Okay. Apologies. I don't have my notes up on the screen, so I'm going to be looking down at my notes, and please don't take offense, anybody. Oh, there, love the angels. Okay, so the first slide, independent contractors. The Federal Department of Labor announced a return to the Fair Labor Standards Act guidance with respect to determining independent contractor status. Basically, it's an economic test, and it's 6 points. The 6 economic factors they look at is the opportunity for the worker to profit or loss, depending on their managerial skill, the investments by the worker and the investments, if any, by the employer, the degree of permanence of the work relationship, the nature and degree of control, the extent to which the work performed is an integral part of the employer's business, and the skill and initiative. Now, for most of us, this doesn't apply because we've got to comply with California's more restrictive and employee favored tests, and that's the ABC test and the Borello test. Just refreshing your memory on ABC, the worker has to be free from control and direction of the hiring entity in connection with the performance of the work. And the worker performs work that's outside the usual course of the business of the employer. And this is where most of workers fail, because they're doing the work that the employer also does. And specifically, if they're doing it to the customers or clients of the employer, easy fail. That the worker is customarily engaged in an independent established business. Excuse me. There are lots and lots of exceptions to this test, specific occupations, business to business. We don't have time to go through them all. Maybe we'll do another webinar again on this because they keep adding exceptions. And when the exception is there, you still have to comply with the Borello test. The Borello test is basically very much similar to the economic factors I just gave you and control factors added to it. It's nearly identical to the IRS's 21 points that it looks at for control. Okay. Leave. Oh, I beg your pardon. I missed the Prop 22 because I don't care. This is for rideshare and app-based delivery drivers. Prop 22 gave them some rights like employees, but allowed them to be independent contractors. And these are their rights. They can bargain collectively. They can form and join driver organization, engage in protected concerted activities. That's because we do not represent any drivers. We do not represent any employers of those types of workers. So if anybody is in this space, you need somebody who handles that as a specialty. Okay, then we have immigration news. If you haven't heard it on the TV or the radio, ICE is out there in full force, and their audits are increasing as well. They've said notice of audits are going to come and correct your I-9s. So it's really important. I just had this conversation with a client this morning. If you have not had your I-9s audited by Linda's office or an attorney, please do so, because once you receive notice of an ICE audit, you can't make any corrections. And there's almost always, we send our audits to Linda's firm as well, and there's all to be corrected. And it's completely legal to correct them when you find the error before you have notice of an ICE audit. The H-1B fee for overseas petitions. This is for workers with specialized knowledge. The fee used to be between $2,000 and $5,000. You can see the Trump administration not liking immigrants coming in, even foreign professionals. So they've upped it to $100,000. This will likely be challenged in the courts like all of Trump's actions. Who knows where it goes? Okay, leave laws, victims leave. So AB 406, it centralizes all the victims of violence related leave under FEHA, the Fair Employment and Housing Act. It brings stronger anti-retaliation protections and clearer enforcements. You now must allow employees to use paid sick leave for a broader set of judicial proceedings listed here. And then it's related to qualifying crimes like post-arrest release decisions, plea hearings, and sentencing. It expands the paid family leave designated person. That person is designated by the worker at the time they ask for the leave, and it can be any care recipient related by blood or whose association with the employee is the equivalent of a family relationship. This is also codified. If anyone, I know some of you are like me, geeks, I like to read the code. It's government code 12945.8. And this is effective January 26th. Okay. employment contract restrictions. This is a little bit confusing. So if you are someone who provides signing bonuses, this does not prohibit that. This is really about training and fees that are paid for training, and there are some exceptions. So if you're an employer who provides training for new workers, you can't then require them to pay you back when you terminate them. This doesn't go into effect until January, though, of 2026. So if you have current contracts that do that, those are still enforceable. But it's a very high risk of litigation if you violate this. So if you are having any kind of contracts or wanting any kind of contracts where there is repayment obligations on separation, please consult with a lawyer or consult with someone like Linda, the HR. Sorry, my light went off. I think that's okay. So we're going to see that a lot more of this, I'm sure. This is AI in employment decisions. These new rules were effective in October. Again, we're going to see a lot of this. You see that down at the bottom of the slide, no Robo-Bosses Act. It was vetoed. It will probably come back and not be vetoed. It requires that a human oversight, like we have in the comment above that. This is the strongest thing I can tell you about this, is please make sure you have human oversight. In my profession, I get people calling and emailing me all the time, say, well, I found this law on AI. And I said, yes, it's just like when you were Googling laws. It's for every other state, but it doesn't apply to California. If you don't know what you're asking, you're going to get trash in, trash out. So here, this law requires lots of auditing, lots of keeping the data, and it's on the employer. It is not on the software provider. So if you're thinking, well, I'm just going to rely on the software provider, they told me that this does not result in any discrimination. You can't do that. So this is something I think will probably pop up of auditors and people who will specialize in this area say, oh, well, AI is going to ruin the economy because people aren't going to have jobs. It's going to create jobs just like all other technology, advanced technology. Okay. And just as a reminder, the Fair Employment and Housing Act regulations apply to any computational process, not just AI. Anything that could possibly result in discrimination, even if it wasn't intended to, if it results in it, that's called disparate impact. So on its face, it looks like it's not discriminatory, but it just so happens that now we've excluded all the Spanish-speaking potential workers. Okay, wage and hour enforcement changes. Hopefully this doesn't apply to any of you. You would catch it beforehand, but if there's a judgment against the employer and it's not paid for 180 days, it triples. Now, any of you who have had labor commissioner judgments against you know that there are already huge penalties and interest and things of that nature already on there. All of it triples. And now it can be enforced by public prosecutors. And this is a very difficult thing, but this has been around forever. Ignorance of wage law is not a defense. I have not seen an employer show reasonable attempt at compliance successfully. Sean probably has, but I have not. So with that, I will turn it over to Sean.
Thanks, Marla. Good afternoon, everyone, and good morning. I was just going to echo what Marla said about that AI. It's really funny. I had a client, I'm starting to see it show up in my practice. I had a client the other day send me a contract they had very obviously generated from AI. And he said, hey, I wrote this contract up. I want you to review it for me. Tell me what you think. And I said, well, it's pretty well written. The problem is it's totally illegal because it's a non-compete provision. So I don't care how well it's written, it's illegal in California. So yeah, always have human involvement on all that sort of stuff. So I wanted to talk for a few minutes about some decisions we had this year in the area of arbitration. I'm sure Linda and Marla feel the same way, love arbitration agreements, but it is one of those areas of the law that is always moving. Always the rules are changing a bit as there's sort of an interplay between federal courts and state courts. And so an employer is always needs to keep updated on what the law is with regard to arbitration agreements. One of the areas that's been interesting in the last couple of years is there was a new law, gosh, been a few years ago now, that essentially said that an employer is always the one who has to pay the cost for mediation. And there was a new rule that said that an employer has 30 days from the issuance of the invoice to pay for it. Otherwise, it invalidates the provision. You go back to big court, and the employer's on the hook for costs and maybe some penalties associated with it. And the reason they did that was because what defense counsel would often do is they would wait to pay until the absolute last moment, hopefully settle the case and never have to pay the arbitrator anything. So this law was intended to undo that leverage. But since then, there have been all sorts of cases about, well, how strict is that? And in this Hohenscheld case, there was dealing with another case, but essentially what had happened was the defense counsel waited until the 30th day to trigger an electronic payment. The payment didn't show up in the arbitrator's office for another few days. And plaintiff said, well, you violated the 30-day rule. So let's go back to big court. And what the California Supreme Court said is, look, this rule, it's California Civil Procedure Code 1281.98, said, look, this isn't a strict liability situation, right? That it doesn't automatically void the arbitration agreement unless the employer is grossly negligent or is willfully skirting the rule. So it added a little bit of common sense to the rule, I would say. So at the end of the day, if you have an arbitration agreement, you want to enforce it, make sure that you pay on time within 30 days to avoid any of these issues. Then you get to the Velarde case, and this one is probably one that you see on the ground more often. In California, there's a test, sort of a two-pronged test that courts look at to determine whether an arbitration agreement is valid. It has to be it can't be substantively unconscionable, and it can't be procedurally unconscionable or unfair. And there's always this balance. You can have the best, most excellent written arbitration agreement, but if you give it to the employee in an unfair way, it becomes procedurally unfair and it's invalid. So what happened in the Velarde case is they hire a new employee. It so often happens in the rush to onboard, the employer hands the employee a big packet of like 31 documents, asks them to do it as fast as possible because they've got training and they need to get moving. Within that big stack is an arbitration agreement. This employee pulls it out and says, hey, wait a minute, I've got a question about this arbitration agreement. And the employer just sort of says, I forget what the HR person said, something along the lines of, that just means that we don't have to get lawyers involved if there's a dispute. I mean, totally wrong, by the way. So she signs it and moves on. Sues the company moves to enforce the arbitration agreement, to force her to go to arbitration. The court deems it to be unenforceable because what it says is, look, it's procedurally unconscionable. You can't hide it amongst a big packet of documents, number one. And two, it's substantively unfair because when she asked you about it, you told her something that was incorrect, right? And so it's incumbent upon employers, if you're using these things, to give them, they need to be in separate agreements. They can't be buried in a handbook, right? They can't be part of a larger employment agreement, number one. And two, you've got to make yourself available for questions about them if they're asked, right? You need to be transparent about them. These are not things, arbitration agreements never work as gotchas. They just never work as such. And courts are kind of always looking for reasons to invalidate them. So you've got to make sure that you've got somebody, if questions arise, these are not questions you answer off the back of off the back of a napkin or just off the top of your head. Make sure you get HR involved, somebody who knows what those agreements say, can answer questions about them. You don't want to rush signatures. You don't want to pressure employees. You want to make sure that you're doing everything above board so you can enforce these agreements later. Because they could be real powerful tools, right? I mean, these will keep you hopefully out of court, in front of a jury, and keep costs down potentially, and potential damages award down. So you want to keep that in mind. Bissonnette, I think is the way you pronounce this. This one is kind of a niche agreement, a niche decision, to be perfectly honest, but an interesting one. This one comes from the US Supreme Court, and it deals with the Federal Arbitration Act. And most of your, probably all of the the arbitration agreements that employees in California have include some language about the FAA, or the Federal Arbitration Act. There is within the Federal Arbitration Act something called a transportation worker exemption. And what it says is that it exempts from its rules a certain segment of employees that are, I had the language in front of me, but essentially it says like seamen and people in certain industries. Seamen, railroad employees, and other classes of workers engaged in foreign or interstate commerce are exempt. It's called the transportation exemption. This case involved delivery drivers. They sued, the company tried to enforce the arbitration agreement, and the plaintiff said, well, wait a minute, we are drivers. We're in the transportation industry. Therefore, this doesn't apply to us. We can sue you however we want to. We can stay in big court. And what the courts essentially said, the Supreme Court essentially got to is it said, look, it doesn't, the label you put on the industry isn't what matters, right? What matters is their duty. What matters are they, what did they actually do? Calling something the quote unquote transportation industry, it's like calling somebody a manager. Just calling somebody a manager doesn't mean they have managerial duties, right? Just calling somebody an employee in the transportation space doesn't do it. So you've got to look at what these duties are, what the employee actually does. So, like I said, this one's a little bit niche, but if you are in an industry where you have delivery drivers or people with like logistics roles, I've got a client who's a bakery, for example, and they send drivers out all the time, this sort of thing, or trucking kind of people, right? If this may be of interest to you, you want to make sure you talk to Linda or another HR professional about how this may impact your business going forward. And this last bullet point is a good one. I'm sorry, Linda, I jumped ahead. I may have already said this, but just to reiterate the point, this comes from the Velarde case again, but just it helps reiterate the point that you can have the best policies in the world, but they don't do you any good if one, they sit at a desk and you never review them or give them to an employee, but two, if you don't enforce them or explain them correctly to employees, right? So if you tell an employee one thing, but the policy is different and they rely on what you told them, you're going to be in a pickle. That's the same thing with arbitration agreements, right? If you are telling employees, well, no, what this really means is X, but the agreement says Y, you're going to be in a hard place to try to enforce your agreement. So like I said, just be on your toes and mind your P's and Q's when it comes to arbitration agreements. Okay, Linda, there we go. Thank you. PAGA reform. So everybody here is probably, and I know Linda and Marla and I have all given a dozen seminars over the years about PAGA, and particularly PAGA reform in the last couple of years. For those who are in the blessed state of not having to deal with PAGA or having dealt with it yet, it's essentially a quasi-class action case, a Private Attorneys General Act case that allows an employee to sue on behalf of the state, the labor commissioner, on behalf of a group of employees. These cases over the years are monsters in a lot of respects, right? And there has been an enormous pushback over the last several years about reform. And there was a movement in the last year, it almost got to the ballot, that would have essentially gutted PAGA altogether. But the compromise was the reforms that have gone into place this year. And there are a couple of places where this has shown up that I think are really valuable. I had my first mediation of a PAGA case this last couple of months that used these new rules, and it was very effective. I mean, it cut the number down significantly. So these are really, it's not all that it could be, but these are powerful reforms. So first and foremost is penalties are capped when an employer can show reasonable steps. So there are a couple of hurdles that take place in a PAGA case. Usually the first way an employer finds out about this case is it gets a letter that the plaintiff or employee has sent to the state, the Labor Workforce Development Agency, LWDA. And that letter says to the state, hey, we're aware of these violations. We want you, state, to do something about it. If you don't, we're going to go ahead and sue. State never does anything. Then they turn around and then the employee sues. There are now, if an employer takes measures but at the time that it gets, I think it's within 60 days of getting that notice, the maximum penalties that can be assessed are capped at 30%. That's a huge reduction in fees. It requires an employer to get moving real quick, and the law is still very new. So what's going to qualify as reasonable steps is still working its way out. There are some factors that are going to be looked at, things like you train managers and supervisors as to compliant rules. For example, what compliant meal and rest break policies. You're going to have to update your policy, right, to make sure that they're compliant with the law. You're going to go back and correct wage statements that were wrong. And you're going to document those so nobody just has to take your word for it later. So, for example, for this client that we did this with, they just upended the way they did wage and hour stuff altogether. They reclassified some employees. They changed their policies. They did a bunch of training. It seems like may seem like a hammer to kill a fly, but it can be really impactful when it comes to assessing damages. Standing there, now this is kind of a legally issue, but it's really interesting because it used to be that once a plaintiff suffered a violation, they could essentially sue for any violation. It's the idea of the camel getting its nose in the tent door, whatever the metaphor is, right? Once they get one violation, they can sue for anything. But now what has to happen is they can only sue for violations that they personally suffered. So if your plaintiff says, I didn't get my meal breaks, okay, they can sue on behalf of people who didn't get meal breaks. They can't now tack an overtime claim on top of that, right? Because they didn't suffer that. Cure options are expanded, but difficult to execute correctly. This is a tough one because I quite frankly haven't had a client do this yet. PAGA has these new opportunities to quote unquote cure all of this and avoid the lawsuit altogether. It is a difficult process. And it requires a lot of documentation and correspondence with the court. But those options are there. They're worth exploring. And I like this one as well. The LWA has said it is going to crack down on boilerplate notices. Linda and Marla may be the same way. I can't remember the last time I saw a PAGA notice that varied from anything I've seen in the last 10 years. I mean, it's just all photocopied, same kind of stuff. So hopefully that further reform will continue to narrow the scope of these cases down. I expect we'll continue to talk about this in seminars to come. Okay, next one, Linda. Okay, a couple of really interesting decisions this year that are worth knowing about. This Ames case is an interesting one. It comes out of the U.S. Supreme Court, Ames versus the Ohio Department of Youth Services. But basically what it is it's a claim under Title VII for sex discrimination, right? Gender discrimination, sexual orientation discrimination. And what's different about it is somebody who is heterosexual claiming that they were discriminated against based on their heterosexual sexual orientation. What had happened was this employee was denied a promotion, and the person who was promoted was a lesbian woman. This employee was demoted, and the position was then filled by a homosexual man. So she brings a claim under Title VII. And what's interesting about this case is prior to this time, there had been a different balancing put into place for minority plaintiffs, essentially, right? There were different standards involved. And if somebody who was in the majority was suing, there was a higher burden because the idea was, well, look, you're already in the majority. Are you really suffering from discrimination? So there's a higher standard of proof. Essentially, the court said, we're just evening the playing field. You know, regardless of your category or stated basis for discrimination, everybody, the same test applies. Be interesting to see that the potential result is going to be more claims. I mean, we'll have to see how that plays out, but I wouldn't be surprised if we see more of those claims coming up from, what some people refer to as quote unquote reverse discrimination, right? We'll see more of those claims coming up. The Hearn case. Let's talk about Hearn for a minute. So Hearn is Hearn versus PG&E. This is a California case. And what had happened was Hearn was a lineman essentially for PG&E, and he was suspended, later terminated after he had messed up his time records, as I recall. He sues them for a couple of things. He sues them for retaliation, he sues them for wrongful termination, and he also sues them for defamation, which is an unusual thing. Goes to trial. The jury finds against him on the retaliation claim, but it awards him damages for defamation, right? And awards him damages. What the Hearn case essentially decides is it says, well, wait a minute. You can't just turn a wrongful termination claim into a defamation claim. They're not the same thing. So in order to have a defamation claim, you've got to have some separate harm, right? Otherwise, they're just kind of tag-along claims all the time, and every wrongful termination is always a defamation. The court said, well, wait, you can't do that. They are separate things, and if you want to have this separate claim, you got to show me a wrong that is solely related to the defamation, right? Got to show me some reputational harm that is independent of termination. You can't just say, well, I got fired and that's embarrassing, i.e. that's now defamation. Can't do it, okay? This is a good reminder to always, I'm sure if you work with Linda, she's told you this 100 times, right? It's always a good reminder to document all the performance issues you have with employees, right? And so when it comes time to making difficult termination decisions, you can back that up, and you've given yourself a lot of runway to do so. Detweiler. Let's talk about Detweiler. This is the Detweiler versus Mid-Columbia Medical Center. This is a federal case, as I recall. I don't remember off the top of my head. This one is interesting. This is another case of the type I think we're going to probably see more of in the coming years. So it's a case about religious discrimination. What it was the employer had a mandatory, in the bad old COVID days, the employer had a rule that all employees had to be vaccinated to come to work. And the employee said, well, wait a minute, that I need a religious accommodation for that. And the employer said, that's fine, as long as you wear your PPO and you get a certain kind of weekly testing. I think it was nasal swab testing. And the employee said, well, wait a minute, that accommodation violates my deeply held religious principles that my body is a temple for the Holy Spirit. Okay. Employer said, but I'll take this other kind of test. And employer said, we're not going to do that. If you're not going to work, we're going to fire you. And they fire her. She turns around and sues for religious discrimination. And her claim was that antigen testing specifically was against her religious beliefs. So what the court said is, look, we're not theologians, we're not religious scholars, but an employee to have a religious discrimination claim, it has to be based on a sincerely held religious belief and not a secular belief that's wrapped up in religious language, right? If I were a judge, I don't know that I would want to spend the time parsing that out. That seems like a real difficult question sometimes, figuring out whether that's an actual religious belief of theirs. But the court said, at least in this instance, it went too far. Right, it was too much. This very specific test, it didn't square with the religious belief. And one of the examples that I've seen that would go the other way is if somebody said, well, wait a minute, I don't want to take a vaccine or to get involved with any medical testing that is based on fetal stem cells or something, because there's abortion involved in that, and I have a deeply held anti-abortion religious belief. That's much more likely to be seen as a deeply held, sincere religious belief. But something like this, the court just didn't get into it. Finally, let's talk about McDaniel v. Kavri. Funny, it's interesting. I had never had a client that was a I've never had anybody who ever did polygraph stuff. I don't know if you ever had, Linda. But then literally like 2 weeks before I gave this presentation, I have a polygraph business who signed up. So it was all of a sudden I had to care about polygraph. California already has a rule, Labor Code 432.2, that makes it unlawful to require applicants and employees to take polygraphs or lie detectors as a condition of employment. What had happened here was they had a couple of thefts at the office, and the employer required employees to take polygraphs as part of their investigation. They didn't give anybody any notice of their rights. They didn't give them the option. They said, come in the room, sit, put the cuff on. However, I've never taken polygraphs. I don't know how it works, but you got to take the test. And if you don't, you're fired. This guy takes it twice, fails it twice, and so they fire him based on that. He turns around and sues for wrongful termination, and he cleverly tacked a PAGA claim for other stuff on there as well. The employee won at trial, and it's just a good reminder that you shouldn't be doing this in the first place. It's always a bad idea. If you have a conversation with me and the word polygraph comes up, I'm probably automatically going to tell you it's a bad idea. We don't need to go any further. It's a bad idea. Linda's probably the same way. But this is a good reminder because it's not only a labor code violation, but it now, under the McDonnell rule, supports a claim for wrongful termination and PAGA liability. So it becomes not just this little, technical violation. It could turn into some real damages. It could turn into some real money. So you're going to be real careful of that. Okay, Linda, next one. And I realize I'm jabbering on real long, so I'll keep it short, I promise. As Linda said, this is, we've done these some years where we didn't even have enough time to get through all of the things that we were rushing through. This is just not one of those years, which is a good thing for employers, right? But always you're going to want to update your handbooks. There are some new leave stuff that we've talked about, the pay transparency piece that Linda talked about, and AI policies. As Marla talked about, it's like when social media first came to be. I'm assuming over the next couple of years, there's going to be lots of revisions to these. This is a good place to start, but this is one that's going to be a moving target going forward, I think. You're also going to just want to confirm, as Linda talked about, your local minimum wage. Make sure you're doing that. And as she emphasized, I see this most often in people raising their minimum wages and forgetting to raise their salary thresholds, which will kill them on the classification piece. Go back and make sure your job descriptions are updated. Make sure your pay scales are accurate and transparent. You want to implement those governance processes like Marla talked about. Again, at least start the conversation this year. Start talking to your HR people, get in touch with, and they'll help, will help you connect with people who are becoming experts on this area. Like there's going to be people really developing an expertise in the coming years. As I talked about, make sure you review your arbitration agreements and how you're using them in your onboarding processes. And yeah, clean up your personnel files. Make sure everything is in top shape in case you ever get audited, in case you get a lawsuit, in case you have to call me or Linda and say, I just got this letter threatening a lawsuit. What do I do? So I think that's it for me.
Linda, could you put the AI slide up and let me just add something to that, since we're concentrating a lot on the AI, appropriately so, I believe. I did not explain, and I just assumed wrongfully that everybody knew what ADS is. That means algorithmic decision systems. And if I was going to ask a question here as a participant, I would say, well, how do I do this? How do I comply with these obligations to conduct these audits and everything? And my answer is, I don't know. The statute doesn't tell you how to do it. So I would start with the basic, look at all your data, retain all your data as you're required to do, and see what the outcome is. Is there that disparate impact? Is there discrimination? However unintended it is, like that, we have excluded all the Spanish speaking people.
Yeah.
We will get, to Sean's point, I think we will get more clarification as they continue to modify this law.
Okay, great. So to your point, Sean, maybe there wasn't as many laws as in the past, but still always complicated and always necessary to go.
All you got to do is violate one, right?
Exactly.
Violate one and you can find yourself in trouble.
It's true. We do have a couple questions that came in, a few about different types of salary and meal and waiver. So that's always something that we talked about in the past, but still comes up every year. If an employee is scheduled for 6 hours, can they sign a meal waiver to waive the meal period? It's a lot to say.
No, super easy. No, the statute's very clear. It has to be less than 6 hours.
Yeah. And where the mistake comes for a lot of people is they say, well, I'm going to schedule them for 5 hours and 59 minutes, but then they clock in like 2 minutes before 8 a.m. and now they've gone over 6 hours. Right. So you have to be really careful about that. So no, if they're scheduled for 6, I wouldn't do it unless you look at it like okay, you have to be out of here by this day. And I just think it's risky. I think they
Totally.
just take 30 minutes. Yeah, Sean?
I just said these rules are so unbelievably persnickety, right? I mean, yeah, I totally good both what you're saying. Absolutely.
Okay, great. Next question that we received is, we advance the money for our employees to attend apprenticeship classes, and we obviously want to return our investment. What is the best way to do that if we can't require payment?
So whoever asked that question, if you would email me, it's Marla, M-A-R-L-A, at mrclawcorp.com. Tell me a little bit more about the apprenticeship program. Like, as I said, there's several exceptions to this. So we just need to see if it falls into one of the exceptions. Like certain government apprenticeships. Send me some a little bit more information, and offline I'll respond to you.
Okay, great.
Yeah, let me ask Sean and Marla something, because one of the things that we've done in the past is we didn't call it like tuition reimbursement. We said the company's going to make you a loan, interest-free, that you're going to pay off over the next 2 years. But for every month you're here, we're going to forgive 1/12th, 1/24th, whatever of the loan. Have you ever seen anything like that?
Yes, I have, and
Sean,
we've done.
you're muted. Yeah.
Sorry.
Yeah.
Go ahead, Marla.
We do that quite often, obviously before this law, but some of it depends on what it's for. So this is really designed towards training. It's really to keep employees who had to go through training, not to have them repay that training. That's why the apprenticeship question is so good, because like I said, there's government loan programs that are exception, tuition reimbursement can be an exception, sign-on bonuses can be an exception. And we usually tie that loan as a sign-on bonus. So that can be allowed. Sean, I'm sorry.
Yeah, I haven't seen it done specifically that way, Linda, but I hear what you're saying. I often see this come up I get employers every once in a while who will just loan people money out of the goodness of their heart. But I think this law says essentially, like, you can't say, well, you're fired. I'll loan you this money, but if I fire you or you leave for any reason, you have to pay me immediately. I think violates this bill. So
well, that's going to be a Barnhill violation, right?
Yeah,
Remember the old case Barnhill? You absolutely can't do that.
I don't like employee loans for any reasons, for that reason. But yeah, to your point, Lynn, I haven't seen it yet, but I get the point.
But what we're seeing more of, especially even in our field, I mean, the legal field, because we have a shortage of lawyers right now, and people are stealing lawyers. We're seeing more of, we'll give you a sign-on bonus of X dollars if you come now. If you stay for 2 years, we'll give you an extra X number of dollars to get them to stay. And that's also legal, but this new law does require certain contracts to be created for it.
Yeah.
Good question, obviously. Okay. For sales managers, so we have someone who's talking about in their company. For sales managers, we pay them all a full salary plus commission. How can we pay a salary rate under the California minimum and have a commission that is included as a portion of the salary? Can they do that?
Well, yes, and the first question I would ask is, are we talking about an inside salesperson or an outside salesperson? If it's an outside salesperson, you can do whatever you want to, because you don't even have to pay them a minimum salary. So the restrictions don't apply to outside salespeople, but by that, we're really clear about they have to be outside any office in front of customers more than 50% of their time. Right? Not just, I work from home. No. You have to be out in the field talking to people, right? That's how the law was intended. If you're an inside salesperson, the rules are completely different, only apply to a couple of industries. And I will just say no one should pay their inside salespeople commission in order to make them exempt. It will not work. More than, it's too complicated. Look at Sean's head. It's like, just don't do it.
100% agree. 100%
don't do it. So that's my answer to that. But reach out if you want to have a further conversation about it. We did an inside outside salesperson webinar. I don't know, last summer maybe, something like that. So if you go out to our YouTube channel, you can watch that. That'll give you some more insight into what the rules are.
Great. You talked a lot, and I know I-9s have been on everybody's mind with all the ICE raids that we talked about earlier this year, and we had a webinar on that also. But what do you have to do exactly to update an I-9?
You're not updating. You're not updating. I'll let Linda answer.
Yeah, so you never update a 99. You recertify if somebody like changes their name or, their legal status changes or something like that, right? Or if they have a work authorization expires. So if you mean update by that, then that's what you do. Otherwise, once you hire them, that form just remains as is. Now you should be auditing them, and we do a lot of audits, like Marla said, for her firm and other firms, other clients as well. Go through to see if they were completed properly. That you should be doing constantly, basically, seeing if there are documents you can shred because they've passed the, retention deadline. Because if you hold on to them, they can be fined, and you don't want to do that either. So there's a lot of different things, and then there's a specific way you need to make corrections. So again, reach out to us if we can help you. We can talk you through some of the basics. We have, literally like a legal size document, double-sided, that has our audit checklist. So it's not an easy answer for what we look at, but some of the common mistakes we see are like the format of the date is incorrect, and it's little ticky-tack stuff like that. Or, on the certification portion, the employer puts documents in the wrong places, or they took expired documents, or they over documented. There's so many different ways that you can get fined on a Form I-9.
Okay. I'm looking here. Someone was asking about the leave laws, but there wasn't anything specific about the leave law. So maybe you just want to touch on it because every year we have a new version of the leave law. So can you just give
Well,
us?
that's a good point, Denise. There's no new leave law.
Yeah.
There's amendments to existing law. So the existing law is in FEHA, and there's just been amendments to expand it, to expand when they can take leave for those criminal things. And the post-arrest release decisions is covered, plea hearings are covered, sentencing are covered. That's just an amendment to existing law. So it's not really new leave law. And the code section, let me see if I can find the code section so you can look at it if anybody wants
Yes,
to.
and that is one of the things that we should update in handbooks, because there really
Yes.
aren't, there's just a handful. I know while Marla's looking at the code section, we actually just drafted a much more detailed AI policy to add to handbooks. Not every client's going to use it, but I figure most of them are. Right now, it's a paragraph that we added last year to our technology resources policy, and then this year it's like, whoa, like, there's so much more going on in that space and so many more people using it that it's right to have a policy where everybody has clear guidelines on what they can use, what they can't use, what they can use it for, what they can't use it for. Always have a human review everything. ChatGPT, I love my ChatGPT, but it gets it wrong, so, it just go around all the time and ask it questions. And I test every once in a while, right? And, I worry when clients call me, like Sean or Marla said, oh, ChatGPT just told me this. And I'm like, okay. But again, somebody said, like, if you ask the wrong question, you're not going to get the right answer. So
That code
sometimes
section,
you can ask the right one. Go ahead, Marla.
that code section is Government Code 12945.8. But to Linda's point, this is an amendment that should happen in your handbook so that you're not having to remember, okay, wait, are plea hearings one of the times that I have to let them go take their leave? If you have it in the handbook, you just pull out your handbook and look and go, oh, yes, there it is. This is what I have to do. Also, just a cautionary tale about ChatGPT for everyone. Unless you're using a higher version of ChatGPT, like 5 or above, and you're paying for it, everything you put in there is put out to the rest of the world. So it's not confidential. So as lawyers, we don't use it that lower level. It's for them to see, for them to use for training, for them to use for answering other people's questions. So just keep that in mind. I love it, by the way. I think ChatGPT is so much fun.
Only if you use it for certain things, right?
There you go.
We are at 12 o'clock. Do we have time for one more quick question?
Go for it.
Sure.
Okay. And I wanted to ask this one because this has come up a few times. So I know I-9 audits. So I know we did a whole thing, and I know, Linda, you did a column on this about using E-Verify, I think, in one of your newsletters. But on the I-9 audit, do you recommend using E-Verify services? If using E-Verify service, are you still required to do an audit?
California, that's usually the highest percentage in some industries. And so, there's certain types of industries where they're more likely to get audited by the government. So government's been auditing a lot of restaurants, obviously, like garment workers, construction, things like that. So if you're in one of those industries, it's not a bad idea to use it. It doesn't cost anything. It's another step in your process, but it will tell you right away if the Social Security number or some other documentation is not legit. So, Sean, you have an opinion, Marla?
No, I agree. That makes total
Yeah.
sense. Yep.
Yeah, I think
100%.
it's more, for me, it's at least in Southern California, more industry related. We have clients across the country that they are required because of the state they're in to use it. And we have some here that just voluntarily used it, but it's usually, it's because, again, of the industry they're in. So,
Yep.
Okay, on that, just a reminder that the webinar will be posted on the Ethos HCS YouTube channel and on the Merhab Robinson YouTube channel. Just want to thank our speakers for today and thank everybody for attending. It's a lot during the holidays, but this is information everybody needs to know. If you do need information, please reach out to our 3 experts. That's what they're here for, to answer your questions. So thank you, everybody. Appreciate your time today.
happy holidays.
Have a nice holiday.
Thank you.
Happy holidays.
Bye-bye.